Hi, everyone. Harry here to talk about a decision from the Western District of Pennsylvania, Pittsburgh, by Judge Stephanie Haynes, a Trump appointee, actually reaffirming that aliens subject to deportation need to have 21 days of notice in order to prepare their challenge. So this comes up, the case of WJCC, in a previous proceeding before Judge Haynes. And at that time, the administration was basically giving no notice and not complying with it being in a language that the prospective detainee could understand. After that episode, the administration in front of Judge Haynes says, okay, we've got a new plan here. We're going to give them the notice in a language they can understand. Very nice of them. And we'll give them 7 days thereafter. So how's that placate you, Judge Haynes? And maybe we can do a compromise here. Haynes says no, and she makes her temporary relief now a injunction that extends, a permanent injunction. Now it would be subject to appellate review, and she sticks with the 21-day requirement. And she goes through, I don't think we have to march through every step of it, but on page 10 and 11 of her 15-page opinion, she gives sort of circumstances where a particular detainee, 7 days just wouldn't cut it. And so it's not simply the arbitrary, I said 21 and 21 it is, but rather her reasoned calculation about you need this much. It really shouldn't matter to the administration. So this guy is right now detained in Pennsylvania. That's why the habeas motion is brought there. In these situations, generally, the detainee or the prospective deportee is detained. So for the U.S., 21 days, 7 days really shouldn't matter, except for the ability of the person to actually get a lawyer, file a motion, and the like. So anyway, Haynes said, I said 21 before, I'm sticking with 21, and here's why your 7 days doesn't cut it. So we have, now notice, by the way, this is sort of a little bit loosey-goosey or federal common law, right? We don't have any statute that she's interpreting, and it may well be that other courts will adopt this as a rough and ready estimate of how much time prospective detainees need. We now know they need more notice. That has to be in their language. So here's one district court saying 21 days. That's what I said. That makes sense. And here's why. So that's how that flies in this one case, and maybe it will influence others. But 21 days is the standard unless the Third Circuit or the Supreme Court says otherwise. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.